Hello, good morning students. Please subscribe the channel, drop a like, share and comment. This is Shree Vishnu Art Press Publications exercise number 5 and 6 on the speed of 160 words per minute. Start. The Honorable Supreme Court considered the issue at length and held that ordinarily it is considered desirable not to restrict the delinquent's right to be represented by counsel or an agent of his choice, but it is different thing to say that such a right is an element of the principles of natural justice and denial thereof would invalidate the inquiry. The right to be represented by counsel or agent can be restricted, controlled, or regulated by statutes, rules, regulations, or standing orders. A delinquent has no right to be represented through counsel or agent unless the law specifically confers such a right upon him. The requirement of rules of industrial dispute insofar as the right of hearing of the delinquent is concerned cannot and does not extend to a delinquent to be represented through counsel or agent. The Honorable Apex Court held that refusal to grant the help of a lawyer is to be examined on the touchstone of the doctrine of prejudice and it cannot be claimed in contravention to the statutory rules. The Honorable Apex Court further held that in a domestic inquiry, reasonable opportunity should be given to the delinquent employee to meet the charge framed against him, and it is desirable that in such an inquiry, employee should be given liberty to be represented by a person of his choice if there is standing order against such a course being adopted and if there is nothing otherwise objectionable in the request made by him. But in a case where the standing order of the employer company provides that in domestic inquiry, only a representative of a union which is registered under the Trade Unions Act and is recognized by the Company Act, there can be no denial of natural justice if the request of the workman who insisted to be assisted by a representative of his own unrecognized union with the object of indirectly obtaining recognition to their union is rejected. A similar issue was considered and it was held that right to be represented by an advocate in the departmental proceeding can be restricted and regulated by the statute or by the service rules including the standing orders applicable to the employee concerned. A similar view has been reiterated in Bharat Petroleum Corporation Limited versus Maharashtra General Kamgar Union 1999 1 SCC 626. In view of the aforesaid settled legal propositions, it is not necessary that in every case the assistance of defense nominee is necessarily permitted. It depends upon the facts of an individual case. However, such facility is required to be given where on assessing situational facts the authority comes to the conclusion that the delinquent was likely to be in a comparatively disadvantageous position if such facility is not provided for and it would prejudice his cause. More so, such an assistance cannot be claimed as a matter of right nor in contravention of the statutory provisions or standing orders applicable to the employee is there. It is settled proposition of law that the date of birth entered in the service record cannot be corrected at a belated stage. Where the date of birth remains in existence for a long time, the same does not require to be disturbed on any ground whatsoever. The onus is on the employee applicant to prove about the wrong recording of his date of birth in his service record by adducing irrefutable evidence. The court has to insist for clear, clinching and unimpeachable evidence in this regard because the relief sought by an employee may entail chain reaction hampering promotional prospects of junior officers and may cause an irreparable injury to them. The Honorable Supreme Court held that while examining the issue of correction of date of birth, the court must be very slow in accepting the case of applicant if issue has been agitated at a much belated stage and it must examine the pros and cons involved in the case even if not raised by the parties. In the said case, the tribunal had allowed application for correcting the date of birth placing reliance on the horoscope and a certificate issued by the retired headmaster of the school showing a different date of birth. The apex court reversed the said judgment, observing that if it was allowed, the applicant would have joined the service when he was less than 18 years of age, and therefore accepting such an application would amount to sanctifying his illegal entrance in service. The court further observed that no reliance could be placed upon the said certificate and horoscope at all. In State of Punjab versus Mohinder Singh, AIR 2005, SC 1868, the Supreme Court held that horoscope is a very weak piece of material to prove age of a person. A very heavy onus lies on the person who wants to press it into service and to prove its authenticity. It requires to be proved in terms of Section 32(5) of the Evidence Act by examining the person having special means of knowledge, and in that context, horoscopes have been held to be inadmissible for proof of age. The Honorable Supreme Court further held that the court must be very vigilant in placing reliance on a document or certificate of date of birth which had been brought into existence for the benefit of the pending proceedings, as the correctness and genuineness of such a certificate is not free from doubt, and the same might have been obtained for getting the relief by such an applicant. The date of birth as recorded in the service book as declared by an officer in the application for recruitment has to be accepted as correct by the central government, and this can be altered only if under sub rule 4 of the rules 1958 it is established that a bona fide clerical mistake had been committed in accepting the date of birth, and once an application has been rejected, it would be a case that there was no bona fide clerical mistake which had been committed.